I'm Gidon, and I'm a lawyer in the Litigation and Dispute Resolution Group here at McCabe Curwood. Did you know that just because you are not a party to legal proceedings does not mean that you are immune to personal liability arising from cost orders made by the court? In particular, if you are a non-party, such as the director of a company that is a party to legal proceedings, and you have materially influenced on your company's conduct during litigation, and you cause the company to act in some unreasonable way that causes unnecessary costs, you may be subject to a non-party cost order. Courts have the broad statutory discretion to make non-party cost orders. The New South Wales Court of Appeal recently exercised its discretion to order Mr. Dalby, a non-party director, to pay for the appellant's legal costs due to his conduct driven by his substantial personal and financial interest in the outcome of appeal proceedings. So here's what happened. In November 2016, Brand 2 Content commenced proceedings in the New South Wales Supreme Court against 3 companies. Mr. Dalby was a director and a major shareholder of all 3 defendants, and up until February 2018, in the same month, Justice Ball delivered judgment in favour of Brand 2 Content. In March 2018, the 3 defending companies lodged an appeal, and his lawyers wrote to Brand 2 Content solicitors requesting a stay of the judgment, on the basis that they did not have the capacity to pay. The letter enclosed financial documents which disclosed unpaid entitlements owing to the family trusts associated with Mr. Dalby. Soon after, the appellant companies rejected an offer of compromise by Brand 2 Content and twice rejected Brand 2 Content's request for security in respect of Brand 2 Content's costs of the appeal. A motion for security of costs was filed by Brand 2 Content later that month. Prior to the motion being heard, one of Mr. Dalby's companies, which was a cross-claimant in the original proceeding, entered into voluntary liquidation with more than $5 million in debt, and the appellant companies ceased using its solicitors. Despite being served with the motion, the appellant companies did not appear at the hearing, and the appeal was ultimately dismissed. Brand 2 Content therefore sought, amongst other things, that Mr. Dalby pay the cost of the appeal. In assessing whether a non-party cost order should be made, the court found the following factors to be relevant. First, Mr. Dalby was more likely the source of funds of the appeal, given the dire financial position of the appellant companies. Second, Mr. Dalby had a substantial personal and financial interest in the outcome of the appeal through, amongst other things, his beneficial interest in his family trusts, which were owed a substantial debt by an appellant company. And third, the appellant companies were insolvent or at the least impecunious at the relevant time, as disclosed by the financial statements in March 2018 letter. Accordingly, Mr. Dalby was found to have conducted the appeal for personal benefit, and the court ordered Mr. Dalby to pay costs, including on an indemnity basis from the date of Brand 2 Content's offer of compromise. This decision serves a strong reminder to non-party directors out there. If you are a director of a company that has the ability to materially influence the conduct of the company that is subject to legal proceedings, you need to ensure that you do not cause the company to act in an unreasonable way that has the effect of unnecessary costs being incurred by any of the other parties to the litigation. So if you want to learn more about non-party cost orders or cost orders in litigation in general, feel free to contact the Litigation and Dispute Resolution Group here at McCabe Curwood, or you can read relevant articles on our firm's website.